AM 650 presents You and the Law, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, hello and welcome to You and the Law for this Sunday morning here on AM 650. It is time to introduce David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver. And welcome back to the show, both of you, David and Ian. Good to see you again.
Good to see you, Sterling.
Now, Ian, I'm going to start with you first because you've traveled the most since we last talked. You've been down to South America and back and to Machu Picchu and the Galapagos Island. You bon vivant world traveler. Good to see you again. How was the summer vacation?
Thanks. It was amazing. It's an amazing part of the world.
I'll bet it was.
Yeah.
Just a real eye-opener, huh? And David, talk to us a little bit about the firm. Tell us a little bit about Hobbs Giroday, and then we'll launch into our discussion today of administration and executors.
Well, we're located across from the courthouse on Howe between Nelson and Smythe. I've been there for about 7 years. Ian and I have worked together for many years, been partners the last 7 years at Hobbs Giroday, and we mainly provide litigation services, estate litigation for people that are having estate disputes. But we also deal with probate matters as well, which we'll be talking about today.
Okay. Now, Ian, in the matter of Vancouver estate litigation lawyers, David just described that's the sort of work you do. Describe in some detail what estate litigation actually is.
Sure. Well, I mean, litigation is really dispute when people are in a dispute, and so in contrast to preparing a will or doing estate planning, we're dealing with people who are having a fight about an estate in some fashion or other.
Okay.
With the exception that we do help people who are appointed as executors under a will or who wish to administer an estate where there's no will. We help them through that process with the court as well, because it does involve a court proceeding.
Right, but the firm doesn't do wills. You're not. That's not what you're in the business of doing. Your part in the legal picture, David, is dealing with those disputes that evolve out of wills. Correct?
That's correct. We don't draft wills. I suppose you could say we pick them apart. Mm-hmm. And we study them and we interpret them and so on. But we're not the people that you meet to draft your will. And if anyone needs help with that, we certainly have lots of people we refer people to for that specific purpose.
I'm sure. Okay, but typically, Ian, when someone is feels beset upon or aggrieved in some way, having been perhaps left out of a will or left a smaller amount of an estate than they had reckoned they were going to receive, is that when they show up at your office?
Well, it's certainly one of the scenarios where someone might show up at our office. The reality is that only spouses and children pursuant to our Wills Variation Act can do anything about that, quite frankly.
Oh, okay. So there are only certain individuals. And you got to understand this right up front here. When we're talking about wills and disputing or litigating wills and estates, there are only a few players that are actually allowed on the field, to use a football analogy, David.
Yeah, in the Wills Variation context, but you know, estate litigation problems can take on a lot of styles and types. Some people don't get their wills drafted properly by trained people, and they end up with wills that have glitches in them, and those glitches become the subject of a dispute.
Okay.
It can be an interpretation problem. It can mean that the will is invalid in totality or in some respect. And all of those types of issues can come up with best intentions of having created a will. But
okay, I'm sorry. I was just going to ask Ian, and I know neither of you particularly are favor this sort of question, but I want to ask you just in terms of the bulk of the population, Ian, of most of us, do most of us have wills? Or is there, in fact, a majority of people who pass on without formally having drawn up a will?
Oh, I think most people die with a will.
Okay.
I think that there's a lot of younger adults who don't have wills.
But that's because they're young adults.
Exactly. They're
young and invincible.
Exactly. But eventually, most of the population gets around to having a will, and it's a very good idea because you want to dictate who should represent your estate after you die and how that estate should be distributed.
I know in my own case, David, when I was young and invincible, my game plan changed with the birth of my oldest child, my daughter. All of a sudden, I was a parent. I had another generation succeeding me, and my worldview changed rather dramatically in a very short period of time, and suddenly I became much more responsible and started thinking about wills. Is that pretty typical?
Oh, I think that's typical. I mean, it's a planning, it's a long-term planning consideration, and as we get older and wiser, we start to think more about the future, and the will is part of a normal part of that planning process.
Ian, what's the most important part of a will? And I know, again, we're not trying to draw business for people to draw up wills, because that's not what you do, but you resolve disputes after the fact. So what is the most important part of any will?
Well, I'm not sure that I would say that any particular part is any more important than the other. The intention of a will, of course, is to deal with your estates your assets after you die.
Right.
And so, I guess in a bigger sense, the gifting of your estate is the primary purpose of a will.
Okay.
But I mean, it does appoint your representative after you die, your executor.
Right.
And it does direct the executor to deal with your debts and liabilities, which have to be dealt with before the net estate is distributed to the beneficiaries.
Now there's another little item that we need to put a big check mark beside, right, David? If you owe money when you die, and you intend to give large sums of money to your descendants, they will see nothing until everything you owe has been paid, correct?
That's true. You're like a business, whether you're a person or a corporation, and you got to pay your bills first. And obviously, income tax is a big important part of that discussion. Sometimes people pass away and they have income tax problems and income tax liabilities. That all has to be dealt with before there is anything available for distribution. And the executor has to be very mindful of that, because you can become personally liable for the debts of the deceased if you don't administer the estate properly. Like a simple example would be distributing the estate and then discovering that there was a liability to Revenue Canada and you didn't have a clearance certificate from Revenue Canada, so you'd now be on the hook personally for that faux pas.
Oh, is that right? Well, I had no idea. And again, on my own personal experience, Ian, I struggled with the executor part. I mean, I didn't have at the time a great deal of assets to worry about, but I really it was a big deal for me to come to terms with, well, who do I want to represent my interests when I'm not around to represent myself? Is that sort of the crux of deciding who you should designate as your executor?
Well, it's an important decision. You need to appoint someone who's got a bit of business sense, who's capable of doing the job, who has the time to do the job,
right?
And someone that you have a lot of faith in, a lot of trust in. So
is it a paying proposition?
It can be. An executor is a trustee, and executors are entitled to claim as an executor's fee up to 5% of the gross value of the estate.
Oh, so you don't have to designate anything in advance. It can be done afterwards.
No, you can have a charging clause, what they call a charging clause in your will, allowing them to be remunerated, at least certain professionals.
Okay.
But the reality is that the typical executor's fee that would be approved by the court is sort of in the range of 1.5% to 2.5%.
Okay.
5% would be a rare, difficult, complex estate.
So is it rude if you choose your brother or your uncle or a close friend to be executor and you decide you don't really want to compensate them? Is that kind of will they take that as a slight, David?
Well, they might. This is an interesting discussion topic, because I sort of see it as a mix of emotion and objectivity. I mean, your ideal executor would be a person who's very organized, understands financial matters, business-like in their behavior.
Right.
those sorts of qualities. But on the other hand, they have to deal with your surviving relatives and be mindful of your family situation, your wishes, and so on. So that's coloring it a bit with emotion and so on. So your ideal person would have all those qualities. They'd be younger than you because it doesn't make sense to have an elderly potential executor because they may not survive you. So, and I think the person also ideally would understand, and you would understand, that it is, in a sense, a job, and it's work. There's some stress involved in it, and it's not something that's just necessarily a walk in the park, so to speak.
Well, it sounds like it can get pretty crazy.
Well,
at your end of the thing with the disputes and the estate litigation, that process can get pretty crazy, I'm sure.
Well, if the underlying beneficiaries, the family, come from a family that's maybe broken up, maybe has had many marriages, maybe has had many deaths, maybe has had many incidents during the family's history, and there's a lot of acrimony, then you're there in the middle of it to distribute and sort out, and you're having to deal with people who all have an interest in it who don't get along with each other. Mm-hmm. So that's when it can become pretty hairy, as you say.
Yeah. Now, Ian, you said at Hobbs Giroday you don't draft wills, but you do provide legal assistance and advice to individuals who have been appointed as executors. Do people contact you going, "Oh boy, I've just been given this assignment. Now what do I do?"
Sure, absolutely. As I mentioned at the outset, there is in order to, just because you're appointed as an executor under a will doesn't mean you get to sort of march off and immediately start dealing with bank accounts in the estate and distributing and so forth. You actually have to get a grant of probate from the court, from the probate registry of the Supreme Court of British Columbia. So there is a court proceeding involved where you file certain material with the probate registry, and they scrutinize it, and after a certain amount of time, depending on how busy the registry is, they will notify you and tell you whether there's some problems with your application or whether you will receive the grant.
And the grant to probate a will means simply to do what? What does the word probate mean?
So a grant of probate means that the court has now recognized that will as the last will of the deceased.
Okay. So it's now a legal, legitimate document.
And therefore it recognizes the appointment of the executor as the representative of the estate.
Okay.
And then all of a sudden, the banks, for example, will say, okay, we can now deal with you beyond simply paying bills in the interim. We can now take instructions from you with respect to the accounts of the deceased.
Oh, okay. So if, for example, a person has investments tied up in a bank, there may be some debts, but there may be some assets in the form of stocks or something like that, then you would have permission upon receiving this grant of probate to begin to liquidate those assets in order to distribute them. Or do people want stock? Do they want money or do they want stock? Or is it necessary to specify, David, in the will, I want those stocks sold and I want the cash given to my dependents?
Well, I'll take a step back because I think it may be helpful for the listeners to appreciate that one of the very first things that an executor needs to do is get the original will.
Aha.
Because without it, the copies are not good enough. And it really ties back to why...
And is that what goes to the court?
Yes, and
and
ultimately when you file for a grant of probate, you give the original will to the court. It's part of the required materials. And it kind of harkens back to when people have wills and make wills, that their executor know where the will is, and why we have a wills registry where you can put the location of the will, notice of it in the wills registry, because it's all about knowing where that will is and finding it.
As in a safety deposit box in a bank, that kind of thing.
And you can do that, and if your executor knows that, then they know where the will is.
Sure.
But that's an important part of the process. Once you have the will, the original will, then you're going to have to take an inventory, and you're going to have to contact the beneficiaries, and you're going to have to follow certain steps and prepare certain materials to get that grant of probate, which is the court's official
permission to go on to the next level.
Recognition that that's the will, you're appointed, and,
right.
and you have that grant. Then the rest of the world will deal with you, i.e. the banks and the stock brokerage firms and Revenue Canada and so on. You show them the grant of probate.
Okay, now obviously this all is predicated upon, you're saying, if this is indicated in the will and if you found the original document, et cetera, et cetera. Well, the big question that remains unanswered at this point and will until after the break is, what happens if you pass on and you don't have a will? What kind of predicament have you left your dependents and your successors in? We'll find out more from Ian Giroday and David Hobbs from Hobbs Giroday. They are Vancouver estate litigation lawyers downtown, and they're also, it's hobbsgiroday.com if you want to check them out on the web. Interesting website too, guys. And we'll be back with more, including what happens if you die without a will. This is You and the Law on AM 650.
This is You and the Law. There's more of the show still ahead on AM 650.